And I asked him, I says, is this your papers? And when I said this, I says, is this all the papers you have? He very quickly put his hands on the papers and drew them away from me and toward himself. He didn't want me to see how deficient he was in having the papers, because the stack is this high, you know, and his stack was about this big. That's sloppy, sloppy law firm. I further underscore Glendora says that he's not familiar with the facts and circumstances of this case. He has no complaint before him. Now I will answer the questions as to what this cause of action is. His cause of action, if he read the complaint, he would know what it is. There again, Mr. Bendich is coaching Mr. Koza, and this is improper. I make these objections. Mr. Bendich, so that the record is clear, I am not coaching my co-counsel. He does not need coaching. Glendora, since when is he your co-counsel? Are you aware that you are representing Alpucci and Walsh and you are not representing Larkin, and that on July 5th, 25th, you did not even know that you were representing Alpucci? Mr. Bendich, do you have anything else that you want to put on the record? Glendora, see, they try to get away with it. I want you to leave. It is improper that you be here. Koza, you have put that on the record. Glendora, he is still here. The time is 2:36 p.m. This deposition started at 2:11. By Mr. Koza. Had you answered my question, we could have been out of here by now, but you refuse. I want you to answer my questions, Glendora says. Koza, do you think that it is time for us to suspend and wait for Judge Wood to return from vacation and lay some ground rules for this deposition? No, 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 no. You have acted in bad faith and have broken over 5 appointments for depositions. That's enough. It is obvious what you are trying to do. You are trying to keep this from going to trial because you know very well that you are going to lose. I am bent upon getting this to trial as soon as possible. Koza, are you claiming that the tortious acts of Andrew Larkin, I am giving you time to write down my question, are related to the fact that he is the father of Kevin? Well, Mr. Koza, when did I ever claim any tortious acts against Andrew Larkin? You named him in a suit. On what basis did? I don't think you heard my question. When did I ever claim that any tortious acts were ever committed by Andrew Larkin? So that the named defendant, Andrew Larkin, the named defendant in this lawsuit, has committed no tortious acts? Glendora, I never said any such thing. The question is, when did I say that Andrew Larkin committed tortious acts? Koza, are you saying that he did not? Glendora, I am not saying that he did not. Koza, did he? Glendora, yes. Koza, when? Glendora, read your log. Read your log, Mr. Koza. Read your log. You are into this without doing your homework. Koza, we are entitled to ask you questions to amplify your pleadings. Glendora, I have answered the questions. Koza, where you were, who was with you, all of the circumstances surrounding everything you claim in this lawsuit, yet every time we try to ask you a factual question, you say, read the log. Yes, read the log. It is in writing. Koza, we are entitled to an oral deposition on your claims in this lawsuit. Glendora, I am entitled to a lot of things that you are not giving me. For instance, a copy of the insurance agreement. Oh, that's nice. Let me show you what I just uncovered. A blank page. That's a lot of deposition on that. And here's another. Now, let's see if the goes from 27 to 28. Okay. Agreement and, for instance, the new address of the Larkins. Harkins is down here. On August the 23rd, which is a Sunday, at 3 p.m., or correction, on July 23rd, which is a Sunday, at 6 p.m., I came to the basement, 21 Greenwich Avenue, and to go to my cellar bin, my storage area, and Andrew Larkin and Kevin Larkin were at the dryer, the clothes dryer, and Andrew Larkin said to me, don't you S blank blank W with me, I am doing the F blank 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 ING laundry. I had said nothing to him before this, I said nothing to him during this, and I said nothing to him after this. What was that date you gave in 1994? Yes, 1994. Are other incidents? You have to go through the log. Didn't you have one when you were serving him? The witness, Mr. Bendich. Why are you coaching Mr. Koza? You are not part of his deposition. I think you should leave. I object to your being here, Mr. Bendich. Mr. Bendich, fine. You have put that objection a number of times on the record. But does he leave? No. Witness, don't make a question. Leave, please. Leave, please. Mr. Bendish, no. Glendora, leave, please. Bendish. Mr. Bendish refuses to leave. Koza, is that conversation with you? It was not a conversation, Mr. Koza. That statement which you attribute to Glendora, 2:45 p.m., Bendish refuses to leave, obviously coaching Koza. Koza, is that statement you attribute to Mr. Larkin memorialized on either audio tape or videotape? Glendora, no. Are there any witnesses to that statement besides Andrew Larkin, Kevin Larkin, and yourself? There may have been. Koza, when you say may have been, what do you mean? Glendora, other people may have been around. What other people? The people upstairs and the people in the other building. What people? Other tenants. What are the names or where do they live? What units? Other tenants. How many tenants are in the building? And he doesn't know that? He doesn't know. Read the log, Mr. Koza. You are not fully aware of the facts and circumstances. I don't see anything to giggle at, and he's giggling. And Bendish is giggling. Why are you so incompetent? Why don't you do your job? It is obvious that nobody here has ever read the log. Why don't you stop making personal attacks on people, Koza says. Why don't you just try and, Glendora, that's just a cop-out. Koza, try and answer the question. Glendora, CPLR, Article 31, I have a right to object to the person taking the deposition. Koza, you have done that. That is in the record numerous times. Glendora, did that cure it? No, it is still going on and I still object. Koza, do you have any lawsuits pending in jurisdictions other than the Supreme Court of Westchester County? Okay, I have to look up the law on that. I don't think that makes any difference in this lawsuit. In other places, Koza says that you have lived. Did you commence lawsuits against neighbors? I gave you my answer to that before. You go to the Westchester County Supreme Court or whatever, and you do your own research and do your own homework. Koza, prior to living at the address where you are now, did you live in Westchester County? My answer is the same. Koza, what is your answer? Do your homework. Look up the lawsuits. They are all a matter of record. Koza, so you children? See, he doesn't answer. Glendora, major request. No children. I had some children that were noisy and they were expensive and I got rid of all of them. Glendora, are you going to answer my question now? What is the address of Kevin and Andrew Larkin, the new address? Koza, we are taking your deposition. Glendora, okay? A dodge and a lie. Let me read you the rule. Rule 3018, demand for addresses of party or persons who possess an assigned cause of action or defense a party may serve on any other matter, a written notice demanding a verified statement setting forth the post office address and residence. Not just the post office address. He tried to get away with that, just giving a post office. Of the party and of any person who possessed a cause of action. These people don't pay any attention to things. Judge Wood ordered them to send me a photocopy of the insurance agreement and they defied it. I am making a motion to Judge Wood to sanction these people. Koza, are you done? Can I ask a question now? Glendora, the time is 2:26 p.m. Koza, do you have other lawsuits pending presently? Glendora, state the relevance of that question to this case. Koza, do you have any lawsuits presently pending where you are alleging tortious acts causing emotional damage and mental anguish and I believe injuries of that nature? Glendora, let me think. Yes. Koza, can you give me the names of the lawsuits and where they are pending? Glendora, why? Koza, what country, what counties? Glendora, why? Why? Is that your answer? Why? Glendora, why? Koza, how many lawsuits are presently pending which fall into the category of claiming damages for mental anguish and things of that nature? Oh, not things of that nature. Make your question specific. Koza, mental anguish. Glendora, it's not mental anguish. Koza, emotional distress. Glendora, I think the law you are looking for is emotional disturbance with no physical effect. Let's get the record straight. Koza, are you claiming emotional disturbance with no physical effect in this lawsuit? Yes. Are you claiming emotional disturbance with no physical effect in other lawsuits? Glendora, I answered your question. Koza, how many other lawsuits presently? And I had to think. And I said one, but I think that's wrong. You go through the lawsuits, there's Scott, and I don't think it was there. And there's Broder, and I think possibly it was there. And Stavis, I don't think so. DHCR, Capola. Lydia, yes. So that would be two at least. And Wall, yeah, that's what it's all about, Wall. And Cablevision, yes. So I think the right answer would be 3, as far as I can see. And as for the lawsuits that are settled and I've won, I don't know. I'd have to sit down and go through them all. And Koza says, where is that lawsuit pending? Glendora, you have to wait until I look up the law on that. Let's see, this is the protective order, this one, okay, let me read to you, CPL 3117. Defective using of deposition of parties shall not be deemed to make a person his own witness for any purpose by taking his deposition. That is wrong. The court stenographer or the person taking the minutes, Mr. Cantonia, that is wrong. The introduction in evidence of the deposition or any part thereof for any purpose other than that of contradicting or impeaching the deponent makes the deponent, and so forth. At a trial, any party may rebut any relevant evidence contained in the deposition. Now, errors and irregularities of the person transcribing the deposition are waived unless there is a motion to, objection to qualification of person taking deposition. I want to go on record as objecting to this person, Mr. Koza, as to his disqualification for taking deposition, as to the competency, and as to his questions. Disqualification of person taking the deposition of the person by whom it is to be taken is waived unless made before the taking of the deposition begins. See, that's why you have to make the objection then. Tape, I don't know what it would be better for to play you the audio tape. Yes, certainly would be better. But it goes on, and he keeps asking questions that are not germane. That's on page 21. He asks, is your other lawsuit the one you claim for mental disturbance similar to... Wait just a second. That's negligent infliction of emotional disturbance without physical effect. Let's get the lawsuit. Let's get it straight. Let's look up the complaint. Have you ever had any, let's find out what the complaint says. Have you ever had any treatment for any psychological injuries or seen a psychiatrist in your life? No. Have you? Have you ever seen a psychologist or psychiatrist or any mental health care provider for any purpose in your life? No. No. In what county is the other lawsuit pending? Is it Westchester? I've given you my answer to that. Go to the county clerk. Go to Judge Wood's grandson. Dean, get the facts. You keep on repeating questions, and I object to that. Koza, have you not filed lawsuits? Show me your summons and complaint. Koza, have you filed lawsuits in federal court? Show me your summons and complaint. Glendora, I object to this examiner. You made that objection about 10 times already. Koza says, Glendora, I object on the new grounds that he will not show me a copy of the complaint. And I asked him, I says, is this your papers? And when I said this, I says, is this all the papers you have? He very quickly put his hands on the papers and drew them away from me and toward himself. He didn't want me to see how deficient he was in having the papers, because the stack is this high, you know, and his stack was about this big. That's sloppy, sloppy law firm. I further underscore Glendora says that he's not familiar with the facts and circumstances of this case. He has no complaint before him. Now I will answer the questions as to what this cause of action is. His cause of action, if he read the complaint, he would know what it is. There again, Mr. Bendish is coaching Mr. Koza, and this is improper. I make these objections. Mr. Bendish, so that the record is clear, I am not coaching my co-counsel. He does not need coaching. Glendora, since when is he your co-counsel? Are you aware that you are representing Alpucci and Walsh, and you are not representing Larkin, and that on July 5th, 25th, you did not even know that you were representing Alpucci? Mr. Bendich, do you have anything else that you want to put on the record? Glendora, see, they try to get away with it. I want you to leave. It is improper that you be here. Koza, you have put that on the record. Glendora, he is still here. The time is 2:36 p.m. This deposition started at 2:11. By Mr. Koza, had you answered my question, we could have been out of here by now, but you refuse. I want you to answer my questions, Glendora says. Koza, do you think that it is time for us to suspend and wait for Judge Wood to return from vacation and lay some ground rules for this deposition? No, 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 no. You have acted in bad faith and have broken over 5 appointments for depositions. That's enough. It is obvious what you are trying to do. You are trying to keep this from going to trial because you know very well that you are going to lose. I am bent upon getting this to trial as soon as possible. Koza, are you claiming that the tortious acts of Andrew Larkin, I am giving you time to write down my question, are related to the fact that he is the father of Kevin? Well, Mr. Koza, when did I ever claim any tortious acts against Andrew Larkin? You named him in a suit. On what basis did? I don't think you heard my question. When did I ever claim that any tortious acts were ever committed by Andrew Larkin? So that the named defendant, Andrew Larkin, the named defendant in this lawsuit, has committed no tortious acts? Glendora, I never said any such thing. The question is, when did I say that Andrew Larkin committed tortious acts? Koza, are you saying that he did not? Glendora, I am not saying that he did not. Koza, did he? Glendora, yes. Koza, when? Glendora, read your log. Read your log, Mr. Koza. Read your log. You are into this without doing your homework. Koza, we are entitled to ask you questions to amplify your pleadings. Glendora, I have answered the questions. Koza, where you were, who was with you, all of the circumstances surrounding everything you claim in this lawsuit, yet every time we try to ask you a factual question, you say, read the log. Yes, read the log. It is in writing. Koza, we are entitled to an oral deposition on your claims in this lawsuit. Glendora, I am entitled to a lot of things that you are not giving me. For instance, a copy of the insurance agreement. Oh, that's nice. Let me show you what I just uncovered. A blank page. That's a lot of deposition on that. And here's another. Now, let's see if the goes from 27 to 28. Okay. Agreement and, for instance, the new address of the Larkins. Harkins is down here. On August the 23rd, which is a Sunday, at 3 p.m., correction, on July 23rd, which is a Sunday, at 6 p.m., I came to the basement, 21 Greenwich Avenue, and to go to my cellar bin, my storage area, and Andrew Larkin and Kevin Larkin were at the dryer, the clothes dryer, and Andrew Larkin said to me, don't you S blank blank W with me. I am doing the F blank 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 ING laundry. I had said nothing to him before this, I said nothing to him during this, and I said nothing to him after this. What was that date you gave in 1994? Yes, 1994. Are other incidents? You have to go through the log. Didn't you have one when you were serving him? The witness, Mr. Bendich. Why are you coaching Mr. Koza? You are not part of his deposition. I think you should leave. I object to your being here, Mr. Bendich. Mr. Bendich, fine. You have put that objection a number of times on the record. But does he leave? No. Witness, don't make a question. Leave, please. Leave, please. Mr. Bendich, no. Glendora, leave, please. Bendich. Mr. Bendich refuses to leave. Koza, is that conversation with you? It was not a conversation, Mr. Koza. That statement which you attribute to Glendora, 2:45 p.m., Bendich refuses to leave, obviously coaching Koza. Koza, is that statement you attribute to Mr. Larkin memorialized on either audio tape or videotape? Glendora, no. Are there any witnesses to that statement besides Andrew Larkin, Kevin Larkin, and yourself? There may have been. Koza, when you say may have been, what do you mean? Glendora, other people may have been around. What other people? The people upstairs and the people in the other building. What people? Other tenants. What are the names or where do they live? What units? Other tenants. How many tenants are in the building? And he doesn't know that? He doesn't know. Read the log, Mr. Kozer. You are not fully aware of the facts and circumstances. I don't see anything to giggle at, and he's giggling. And Bendish is giggling. Why are you so incompetent? Why don't you do your job? It is obvious that nobody here has ever read the log. Why don't you stop making personal attacks on people, Kozer says. Why don't you just try and, Glendora, that's just a cop-out. Kozer, try and answer the question. Glendora, CPLR, Article 31, I have a right to object to the person taking the deposition. Kozer, you have done that. That is in the record numerous times. Glendora, did that cure it? No, it is still going on, and I still object. Kozer, do you have any lawsuits pending in jurisdictions other than the Supreme Court of Westchester County? Okay, I have to look up the law on that. I don't think that makes any difference in this lawsuit. In other places, Kozer says that you have lived. Did you commence lawsuits against neighbors? I gave you my answer to that before. You go to the Westchester County Supreme Court or whatever, and you do your own research and do your own homework. Kozer, prior to living at the address where you are now, did you live in Westchester County? My answer is the same. Kozer, what is your answer? Do your homework. Look up the lawsuits. They are all a matter of record. Kozer, so you refuse. Glendora, we have Rule 3114, examination of witness who does not understand the English language. I think that you have a problem, Mr. Kozer, in understanding the English language. Objection to qualifications of person taking the deposition, competency questions and answers. Wait, there's another one I want to look up here. This is under discovery, under what you asked the judge for an order of protection. Okay. Kozer, when this mental anguish occurs as a result of the Glendora, you read me the law on mental anguish. No, that's not right. Something screwy there in the record. Question, whatever it is. Glendora, whatever it is. Kozer, have you ever taken any over-the-counter medications for any of the distress that you have suffered? Glendora, no, and that's not an issue. Physical injury is not an issue. If you read the log, I will read it to you in fact. Now has Glendora, that's not an issue. Physical injury is not an issue. Do you understand that, Mr. Kozer? Kozer, how have the incidents of mental distress affected you? Glendora, repeat your question. Kozer, it is in the record. Mr. Kozer, read the question. The pending question was read. Glendora, I think that you have answered your own question. The tortious acts have distressed me greatly. Kozer, in what way? Verbalize the way the acts distress you. I can't exit my apartment or enter my apartment without fear of being accosted by one of these tortfeasors, Andrew Larkin or Kevin Larkin. In what way do they accost you when you exit? Taunting, abusive language, insulting language, obscenities, harassment, intent to annoy and alarm with no legitimate purpose. Kevin Larkin, when Franklin and I go to the car, he says, look guys, the circus is leaving town. Many, thousands, well not thousands, but dozens. Have you called the police on these people? Glendora, have you read the record, Mr. Kozer? I'm not going to answer a question that I've already answered in the record. Kozer, do you claim that children bouncing basketballs are trying to intentionally harm you? Kozer, Glendora, tell me about what you know about children bouncing basketballs. Kozer, do you claim that children on skateboards are trying to intentionally harm you? Glendora, where did you get that question from, Mr. Kozer? Kozer, do you claim that children talking to each other? Glendora, what is the basis for the question? Kozer, are trying to intentionally harm you? Glendora, what is the basis for this question? I would like to add to the list above the violation of the White Plains Noise Ordinance, which is shouting, hooting, hollering, so as to disturb a person's peace, repose, or in any dwelling or residence, and Kevin Larkin must have broken that 200 or 300 times on 300 counts. Do you have 300 tortious incidents listed with regard to Kevin Larkin? I think we kept a log of that, Mr. Kozer. I think that is the time, and it is time for you to read it. See, he's trying to get out of it by saying, you know, bouncing a basketball, well, that doesn't break any law. No, it certainly doesn't. But what breaks the law is the noise, and what breaks the law is the taunting, and what breaks the law is the harassment, and what breaks the law is the intentional infliction of emotional distress. When the defendant knows that this is causing emotional distress, and when the defendant knows that that's the reason he's doing it. How many times have you called the police with regard to the... Answer your own question, Mr. Koza. It is in the record. Count them up. To your knowledge, have any of the defendants in this lawsuit been charged with any of the violations of statutes that you allege? What do you mean, Mr. Koza? Has any law enforcement agency pressed any charges against the people that you complain about? The White Plains Police will not press charges unless they see it happen themselves. And I can make a citizen's arrest, and the White Plains Police are opposed to helping me to make a citizen's arrest. They have failed to do so. Do you have a copy of the complaint, Mr. Kozer? You're not going to answer, right? He wouldn't answer. I said, you're not going to answer, right? Mr. Bendish is still here, and he shouldn't be. The time is 2:54 p.m. Has Andrew Larkin ever blown a car horn? Kozer actually asked me that question. Has Andrew Larkin actually ever blown a car horn? I have not known Andrew Larkin all of my life, and I have not followed Andrew Larkin all of my life. So I really don't know if he's ever blown a car horn. Glendora, how do I know whether Andrew Larkin has ever blown a car horn? Koza, numerous of your complaints deal with people blowing car horns. Do you have any recollection of Mr. Larkin blowing a car horn? No. Wait a second. No, I do not. Have you broadcast videotapes of Kevin Larkin on your public access TV shows? Glendora, no. Koza, have you broadcast audio tapes of Kevin Larkin on your TV shows? Glendora, no. Koza, do you intend to do two as you sit here today? Glendora, no. Koza is stopped. I wait for him, and then I say, for the record, I would like to point out that the incompetency of Mr. Koza again. He doesn't know the difference between broadcast and cablecast. Koza, I assume then you have cablecast videotapes? Glendora, as to what you assume is not my business. Koza, fine. Have you? Have I what? Cablecast videos of Kevin Larkin. Yes. Have you read the record, Mr. Koza? Glendora, Koza, on how many occasions? Have you read the record, Mr. Koza? And that would be a matter of counting. You'd have to go through the record and count how many occasions. Koza, on how many occasions? Glendora, Mr. Koza is not fully familiar with the facts and circumstances of this case. Mr. Koza, I think that I will suspend my deposition at this time. I will wait for a copy of the transcript, and I will let Judge Wood decide as to whether he will permit me to continue in an orderly manner. Whatever the court decides, I will abide by. Gee, that's nice of him, isn't it? Yeah, we really all appreciate that, Mr. Koza. Thanks for cooperating. Trying to question you, Koza says, on record, is a waste of time at the present time. Glendora, because you are so incompetent. It is a waste of time because you are not qualified to do the deposition. I have objected to this pursuant to Article 3100 of the Civil Practice Law and Rules. The time is 2:57 p.m. and Mr. Koza is leaving. Mr. Bendich, and I am still here. The witness. That's very funny. And they left. And it was 2:57 p.m. We'll sign this. First, I'll have to make my corrections. There are several errors in it. And I will have to sign this saying, I, Glendora, the witness herein, having read the foregoing testimony of the pages of this deposition, do hereby certify it to be a true and correct transcript, subject to the corrections, if any, shown on the attached page. Glendora. Yeah, subscribe and sworn to it. Yes, I think I will swear that it is correct, except for those corrections. Broke a law twice yesterday afternoon. She drives up in her red truck. she drives up in her red truck and she blasts the horn twice into our dining room window. That's against the law. And this morning, last night rather, we cleaned out all of our storage bin, and it's very nice. It's just sweet and clean and neat, and took out all of the file boxes, there must be 40 of them, and then put them all back. It's just perfect. And so while we were doing that downstairs, we noticed that the water was gushing out of the back of the brand new washer, and instead of going up into the set tubs, the water was going all over the floor. So we swept it up. That took 20 minutes. That's
okay. This is Roberta Walsh talking to me, and the time is 10:40 a.m. and I just got through talking to Officer Fisher.
Yeah, Officer Fisher called this morning.
The date is...
I won't even look at her. I won't talk to her.
September the
But she keeps up the harangue. Nobody's
Thursday.
talking to her. Nobody's looking at her.
Johnny where the
But she
leak
just
is in
keeps
the
it up.
washing machine.
So Johnny came, and Johnny maintained it was the set tubs, and Caesar worked an hour and a half on the set tubs. So I decided that if Johnny wasn't going to believe what I told him, that I couldn't waste my time. I had too much to do up here.
This is Roberta complaining to Johnny. Okay, and Johnny is not at all interested. Johnny doesn't care.
And so she goes on with her taunting, Roberta does.
This is Roberta Walsh on audio tape.
Now, Caesar was here. He's still working on 2B. You know, an apartment after 21 years takes a lot of work to get it back into shape. So I went over and I told Caesar that Johnny was claiming that the water came from the set tubs. But then I had to go back to work. I really couldn't do that any longer and help him. And so that would be about Tortious Act 880 or so. And what was she doing there? She was taunting and she was harassing. And that was today, about a couple of hours ago, on September the 8th, 1994. Thursday, on perfect weather we're having. And I think that's all that happened on Glendora versus the law-breaking of Daniel Walsh, James Walsh, Roberta Walsh, Nella Alpucci, Theo Alpucci, Andrew Larkin, and Kevin Larkin on the week of September 1st to September 8th. Kenneth says he's lost in thought, and his wife says that's because it's in unfamiliar territory. And Paula says, I always did want to marry a man of letters. And her friend says, and she did, she married a man who works for the post office. And Harry says he's a self-made man, and his mother-in-law says, gee, it's nice of him to take the blame. A newspaper about literary symposia, and they have given awards, and over the years they gave an award to E.B. White of Mount Vernon, and to Alfred Knopf of Purchase, and to Roger Strauss of Purchase, and to Merrill Folsom of White Plains. That's our friend Merrill Folsom, my cousin, the man who's 92 years old and was a reporter for the New York Times. And then he became bureau chief up here in White Plains for the New York Times. And he worked for the old New Rochelle Star before it became the Standard Star, before it became Odious Gannett. And on Monday, Labor Day, his wife, Eleanor Folsom, was 91 years old. And her daughter was stuck going between Spain and Boston, and her other daughter was stuck on Nantucket Island, and her son is way down in Asheville, North Carolina. So I said it mustn't be. So Franklin and I baked a cake, and we went up there, and we had a birthday party, and it was so nice. And we sang her happy birthday. 91 years old, and they've been married 70 years. Cablevision, Glendora versus Dolan and Cofalt and Lusgarten and Randolph and Quinn and Bell and Osnira and Garger and Lemley and Polinsky and James Dolan. The big news there, other than the fact that Cablevision bought Madison Square Garden along with ITT for $1.1 billion, is that the same week they did that is the same week about that the Chat with Glendora goes back on cable TV in Long Island. The first program on the return will be tonight at 11 p.m. and it'll be Thursdays at 11 or 11:30 for the month of September, and then starting in October it goes back to its own slot, which was 10 p.m. Channel 25 every Friday night, and that's in every town and city and village in Nassau County, and it's also in Islip, Babylon, and Huntington in Suffolk County. It's a big city.
When you say you make a report, is this a report that I can go to the report and records place and buy a copy of?
Yes.
Okay, and would that be ready possibly Monday?
No, it takes 2 business days.
That's okay then, Tuesday.
Or Wednesday.
Wednesday. Okay.
Okay.
I thank you for calling.
All right, Mrs. Bill.
Goodbye.
Bye-bye.
The time of that call is 12:45 p.m.
Gallicano stealing our garage. coverage, and they're claimed to have over 400,000 subscribers, to be the biggest single system in the United States. So that is a true victory, and you didn't really feel the victory until that actually happened, because there was question that Cablevision would be dumb enough to, when they did file a notice of cross appeal in the appellate division, that they would be dumb enough to ask for another stay. Now, Glendora's reply brief on the third lawsuit brought against Cablevision on this matter was submitted to the United States Court of Appeals on Friday, September 2nd. That's the day that it had to go out, and that's the day it did go out. 10 copies, and then 1 copy to Sadley, Burke, and Stevens, or Sadley, Stevens, and Burke. And you must bear in mind about a woman named Maureen Martin, who was a law clerk on the Glendora versus Cablevision, the first lawsuit that came before Judge Bryant, that she was the law clerk, a law clerk for Judge Bryant at that time, and now she has gone to work for Sadley, Stevens, Burke and Burke, the company that represented Cablevision. So you wonder about that decision. You wonder a whole lot about that decision. And not only that, but many other things. But I will take 30 seconds of my oral argument to make that point. That it was Glendora versus Cablevision before Judge Bryant, and that the law firm representing Cablevision was Sadlerly, Stevens, Burke and Burke, and that now Judge Bryant's law clerk at that time has gone to work for Sadlerly, Stevens, Burke and Burke. And what is this? Oh, my. This is an amicus curiae brief, friend of the court. And that was submitted to the United States Court of Appeals on the same day, September the 2nd, as my reply brief went in. And I'm allowed 5 minutes oral argument, and that'll be on September the 20th, and these two lawyers, Perry and Grafman, are allowed 5 minutes. And Kalaji will get 10 minutes. Well, that's good, because Kalaji will just make a fool of himself twice as long. He can make a fool of himself in 5 minutes, but now he can do it in 10. And this is Glendora, Cablevision Systems Corporation, Charles F. Dolan, William J. Bell, Mark A. Lusgarten, Francis F. Randolph Jr., John Totter, James F. Colfault, Joseph Asnara, Thomas Gardner, and William Quinn. On appeal from the United States District Court for the Southern District of New York, brief of amicus curiae, Media Access, New York, in support of plaintiff appellant Glendora. Robert T. Perry, 509 12th Street, number 2C, Brooklyn, New York. Brian Grafman, 520 Madison Avenue, 4th floor, New York, New York. Attorneys for amicus curiae. September the 2nd, 1994. And they claim that Media Access of New York has no corporate, parent, subsidiary, or affiliate that has issued shares to the public. Table of contents. Preliminary statement, statement of facts, proceedings below, argument. Here's the argument. Glendora has adequately stated a First Amendment claim for relief. A, Glendora's averment that the Nassau County Executive put pressure on Cablevision to censor her weekly public access series renders that censorship state action. Well, I didn't quite put it that way. I said that I had reason to believe that there was judicial pressure or political pressure on Cablevision to take Glendora's program off the cable. B, even absent any averment of official pressure to censor Glendora's weekly public access series, Cablevision censorship is state action because public access channels are public forums. C, Cablevision censorship of Glendora's weekly series from the public access channels of its Nassau County cable system clearly violated Glendora's free speech rights. 2, argument 2. Glendora stated an adequate claim for relief under Title 47 United States Code, Section 531E. 3, relief requested. And conclusion. Pursuant to the court's expedited briefing schedule, Amicus Curiae Media Access New York respectfully submits this brief in support of plaintiff Glendora to the above caption appeal. And then they also mention Glendora versus Dolan et al. Despite other ongoing and pressing responsibilities over the last 2 weeks, counsel has met the court's understandably expedited briefing schedule and attempted to address the salient issues, although the circumstances may have prevented a complete discussion of every important issue posed by this case and the related case currently pending before the court. That's the third lawsuit, Glendora versus Dolan. The second lawsuit was the one that Glendora won in the state court. So these two are being appealed, Bryant's bad decision and Broderick's bad decision. And how does this sentence continue? First impression in this circuit, whether the sole cable operator franchised to serve Nassau County, and you got to remember that, there's no other cable operator out there, may, under pressure from the county executive, censor a weekly series of public access programs that address consumer fraud in that county and that criticize local public officials who may have allowed that fraud to continue, whether the public access channels over the sole cable system in Nassau County are not only vital outlets for local community expression, including core political speech, but also public forums where government ability to regulate expression is severely limited, whether the cable operator's editorial control of such electronic public forums is state action, quote unquote, subject to scrutiny under and in violation of the First and 14th Amendments of the United States Constitution, and whether the federal statutes on cable television forbid the cable operator from exercising editorial control over the public access programs in question and create an implied right of action enabling the producer of such public access programs to enforce that ban on cable operator editorial control. Well, Judge Silverman certainly said it did. Amicus Manni is a coalition of individuals living in the metropolitan New York City region. You know about that. Prior to our argument, however, we briefly set forth the salient facts alleged by Glendora in her complaint because several key factual affirmants were ignored by the court below, that would be Bryant, in ruling that Glendora had failed to state a claim for relief under the First and 14th Amendments. We also briefly summarized the proceedings in the court below in an attempt to clarify some of the procedural puzzles in this case. And then comes the statement of facts. Well, I think you know that. Let's see if there's any side comments on them. Perry and Grafman say, like many other MSOs, that's a multiple system operator. In other words, a cable operator who operates more than one system. Cablevision is a vertically integrated enterprise owning not only cable systems, that is hardware, but also holding equity interests in cable programming services. These include regional sports networks such as Sports Channel New York and News 12 Long Island, Cablevision's 24-hour regional news channel. But, and we got to add to that, now they own an arena, Madison Square Garden, and now they own a basketball team, the Knicks, and now they own a hockey team, the Rangers. Though we believe that Glendora has presented a cogent and compelling argument, her pleadings are not the most artfully drafted documents. Glendora's pro se. Accordingly, in discussing the procedural history of this case, we have attempted to clarify Glendora's pleadings in the court below because we believe such clarification is essential to a full understanding of the procedural and substantive issues on this appeal. To be sure, we have liberally construed the averments in Glendora's complaint, but that is the appropriate course, not only because Cablevision has moved for dismissal of the complaint for failure to state a claim for relief, but also because Glendora brought this action pro se. There's the question of service being proper. Well, they say we understand from Glendora that subsequent service has removed this issue from the case of Judge Bryant's decision. I really don't. What I'm asking for is that the United States District Court make the right decision and award me the damages and reinstate the rights. And now you have a question before that court. Bryant would not order that the program go back on the cable, right? But Silverman did, and it is back on the cable in Long Island. So you ask yourself, what is going to happen to that issue? Perry and Mr. Grafman say, the document initially served with the summons upon Cablevision was not only a complaint but also a motion for a temporary restraining order and preliminary injunction, seeking immediate restoration of Glendora's weekly series to the public access channels of Cablevision's Nassau County cable system in the very same time slot, 10 p.m. each Friday, that it had previously been cablecast. Not only was this document entitled a complaint and motion for interim injunctive relief, but there was also an allegation of irreparable harm and a prayer for interim relief. To be sure, Glendora set no return date on her motion for interim relief, but during oral argument before Judge Bryan on February 18, 19... Not only was the document entitled a complaint and motion for interim injunctive relief, but there was also an allegation of irreparable harm and a prayer for interim relief. To be sure, Glendora set no return date on her motion for interim relief, but during oral argument before Judge Bryan on February 18, 1994, she did request a preliminary injunction and temporary restraining order immediately restoring her weekly series to the public access channels of Cablevision's Nassau County cable system. Judge Bryant's oral decision on February 18, 1994, thus not only expressly granted Cablevision's Rule 12b-6 motion, but implicitly denied Glendora's cross motion seeking a temporary restraining order and preliminary injunction. Accordingly, at issue on this appeal is not only whether Judge Bryan erred in ruling that Glendora had failed to state a federal claim for relief, but also whether Glendora's motion for interim injunctive relief should have been granted. So they're challenging Judge Bryan on those two things. There are some further procedural puzzles in the disposition below. On March 14, 1994, Glendora served and filed a motion pursuant to Federal Rules of Civil Procedure 60, requesting Judge Bryant to vacate and reconsider his February 18, 1994 oral decision, dismissing her complaint for failure to state a claim for relief under federal law. For the very first time, she cited Title 47 of the United States Code 531E, which clearly bars Cablevision's censorship of Glendora's programming from the public access channels of its cable system in Nassau County, regardless of whether such censorship is state action or under color of state law. 2 days later, on March 16, 1994, Glendora filed her notice of appeal of Judge Bryant's February 18, 1994 oral decision. For some unknown reason, her Rule 60B motion was docketed after the notice of appeal, even though it had been served and filed before the notice of appeal. On March 22, 1994, Judge Bryant denied Glendora's Rule 60B motion on the apparently erroneous ground that the motion had been filed after Glendora had filed her notice of appeal. Glendora evidently did not file a notice of appeal of Judge Bryant's March 22, 1995 for denial of her Rule 60B motion, but instead commenced another action against Cablevision, asserting a claim under Title 47 of the United States Code 531E. Glendora's second action was assigned to the Honorable Vincent Broderick, who subsequently dismissed her complaint on May 5, 1994, in part on the ground that she had again failed to state a claim for relief under federal law. It's called Glendora v. Dolan, and it's on Lexus 5993. Glendora's appeal from Judge Broderick's decision is the related case before this court. The standards under which, now here comes the argument. Boy, I'm glad I don't have to answer this paper. Woo! Tough. The standards under which federal courts must consider Rule 12b-6 motions are well established in this circuit. Complaints are not dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. In addition, the well-pleaded material facts alleged in the complaint are to be taken as admitted. Perhaps because he did not appreciate the full force of Glendora's case, Judge Bryant incorrectly applied these standards in orally ruling in the court below that Glendora's complaint failed to state a claim for relief under federal law. 1. Glendora has adequately stated a First Amendment claim for relief. To be sure, the First and 14th Amendments only prohibit state but not private action that infringes on free speech. Nonetheless, Judge Bryant erred in ruling that Cablevision's censorship of Glendora's weekly series from the public access channels of its Nassau County cable system was purely a private choice and not state action subject to constitutional scrutiny. The mere fact that Cablevision is a private entity does not automatically foreclose the possibility of state action under the circumstances alleged by Glendora. Indeed, for the reasons set forth below, Cablevision's censorship of Glendora's weekly series of public access programs clearly constituted state action. Footnote. Glendora's First Amendment claim is, of course, brought under Title 42 United States Code 1983, that's a civil rights rule, which provides a remedy for deprivation of federal rights under color of state law. While the state action inquiry under the First and 14th Amendments and the under color of state law inquiry under Section 1983 are not identical, conduct satisfying the state action requirement also satisfies Section 1983's under color of state requirement. A. Glendora's averment that the Nassau County executive put pressure on Cablevision to censor her weekly public access series, if true, renders that censorship state action. Private conduct may constitute state action if close scrutiny reveals the conduct to be fairly attributable to the state. The inquiry necessarily turns on whether there is a sufficiently close nexus between the state and the private conduct so that the matter may be fairly treated as that of the state. Such nexus is established by showing that the state has compelled or significantly encouraged the public conduct at issue. Glendora has more than adequately alleged significant state encouragement, perhaps even compulsion, of Cablevision's censorship of her weekly series from the public access channels of its Nassau County cable system. Literally, reading Glendora's allegations, as the court must do, her averment that Nassau County Executive Glendora may have put pressure on Cablevision to censor a weekly series from public access channels in Nassau County could mean that the county executive made plain to Cablevision his strong preference for censoring Glendora's series. Moreover, other factual averments led evidence to that reading because they suggest a motive for such official pressure on Cablevision, Glendora's recent programs on the alleged fraudulent conduct of Nassau County home improvement contractor Scott Lord also criticized certain county officials who, in Glendora's view, have allowed Mr. Lord to continue his fraudulent conduct. Have they ever? A striking parallel thus exists between the case in Missouri Knights of the Ku Klux Klan versus Kansas City. Even though censorship of that viewpoint was ultimately accomplished by the cable operator's decision not to carry the Knight's weekly programs, that censorship had been significantly encouraged by the city council, leaving no doubt that it was fairly attributable to the state. B. Oh, wait, we have a footnote here I guess that you should hear first. Cablevision may well have its own strong preference to keep Glendora off of cable channels in Nassau County, as the reasons cited by Mr. Gargill simply do not make sense. Surely, programs on consumer fraud and official nonfeasance in Nassau County are pertinent to the general population. I've maintained that all along with you, haven't I? And if Cablevision deems Glendora's discussions over individual difficulties with Mr. Lord to be inappropriate on the public access channels over its Nassau County cable system, why does it continue to carry Glendora's weekly series on the public access channels of its Westchester County cable systems? To the extent that Cablevision may itself prefer to censor Glendora's series in Nassau County, such preference may well derive from a corporate concern that Glendora's attacks on local businessmen in Nassau County may have a detrimental effect on local advertising revenues for Cablevision's own 24-hour news service, Cable 12. News 12, Long Island. In any event, it is well settled that state action may be present even if a private party would have acted as he did, independently of the government's significant encouragement. B. Even absent any averment of official pressure to censor Glendora's weekly public access series, Cablevision censorship is state action because public access channels are public forums. Cablevision's decision remains state action because these channels are not only vital outlets for local expression in Nassau County, but also electronic public forums where regulation of expression, whether by public community access organizations or private cable operators, is automatically state action subject to the constitutional scrutiny regardless of the technicalities of property ownership of public access channels. Here's another footnote. Public easement. While the facilities that comprise a cable system are privately owned in most communities, private cable operators do not necessarily own every channel of communication over their cable systems. Indeed, Amicus believes that every cable franchise agreement designating cable channels for public access creates a public easement of those channels. That cable operators do not own public access channels is apparent from the fact that federal and state laws, which have been incorporated by reference in most cable franchise agreements, largely bar cable operators from excluding speakers from those channels. The power to exclude has traditionally been considered one of the most treasured strands in an owner's bundle of property rights. Loretto versus teleprompter. Remember teleprompter? No, you're too young. Teleprompter was one of the first cable systems in the United States. They started in Pennsylvania, and then they ended up owning the one in Manhattan, north of 87th Street, or wherever it is, the one that is now Paragon. And the owner of that was Kahn, and he was convicted of felonies and crimes and sent to prison. Whenever speakers seek access to public property or to private property dedicated to public use, the public forum doctrine is triggered. Indeed, the Supreme Court has repeatedly applied public forum analysis in cases where speakers have sought access to private property dedicated to public use. And page 12 and page 13 are all arguments that the public access channels are public fora. And page 14 continues, and there are maybe as many as 6 or 7 citations per page of laws that have declared this to be so. 15 and 16 are more strong argument on that point. And C, this is C point of the first point, Cablevision censorship of Glendora's weekly series from the public access channels of its Nassau County cable system clearly violated Glendora's free speech rights. Assuming that Cablevision censorship of Glendora's weekly series of public access programs was state action, as Amicus believes to be the case, that censorship cannot possibly survive constitutional scrutiny. Whatever the true reasons for censorship of Glendora's public access programs, the undisputed facts make clear that the censorship, quote, implicates 3 central concerns in the First Amendment jurisprudence: regulation of political speech, regulation of speech in a public forum, and regulation based on the content of the speech. Person versus Freeman. First, the censored public access programs included core political expression. There is practically universal agreement that a major purpose of that amendment was to protect the free discussion of governmental affairs. For speech concerning public affairs is more than self-expression. It is the essence of self-government. How can you vote intelligently if you don't know the facts? And I was telling the facts. Glendora's criticism of Nassau County officials who, in her judgment, had improperly allowed Scott Lord to continue his alleged fraudulent conduct was surely core political expression, given that it discussed governmental affairs in Nassau County. And you remember Norm Fine's lie that these programs weren't about Nassau County? Second, the censorship occurred in a traditional as well as designated public forum, both of them. It's a traditional public forum and it's a designated public forum. The public access channels in Nassau County, where regulation of expression, quote, is subject to the highest scrutiny, unquote. Third, the censorship was clearly content-based, since Cablevision's stated reasons for discontinuing carriage of Glendora's weekly series were all based upon the content of her programs. A content-based exclusion from a traditional public forum survives constitutional scrutiny only if, quote, necessary to support a compelling government interest and narrowly tailored to achieve that interest, unquote. Simply put, Cablevision censorship of Glendora's public access programs cannot possibly survive such scrutiny. No legitimate governmental interest, let alone a compelling governmental interest, has been thus far suggested to justify that censorship. Now we go on to point 2. Glendora has stated an adequate claim for relief under Title 47 of the United States Code 531E. Even assuming, arguendo, that Cablevision's censorship of Glendora's weekly series of public access programs were not state action, which it is, Glendora would nonetheless have a claim for relief against Cablevision under Section 611E of the 1984 Cable Act, which provides, with certain exceptions, not relevant here, that a cable operator shall not exercise editorial control over any public access channel. Title 47, United States Code, Section 531E. That's the old famous 531E. Cablevision censorship of Glendora's public access programs was clearly an exercise of editorial discretion over the public access channels in Nassau County. Judge Broderick's ruling in Glendora v. Dolan that Cablevision was not subject to Section 611E strictures because it was an intermediary, quote, unquote, rather than a cable operator, quote, unquote, was simply wrong. A cable operator is defined by the 1984 Cable Act to include, quote, any person or group of persons who provides cable over a cable system and directly or through one or more affiliates owns a significant interest in such cable system. That's Title 47 United States Code, Section 522.4. Cablevision clearly falls within the plain meaning of that definition. Courts must presume that a legislature says what it means and means what it says. Judge Broderick didn't do that. Not only does Section 611E fully applicable to Cablevision, is it fully applicable to Cablevision, but Glendora's rights under the section are enforceable through an implied right of action. When the statute itself is silent as to whether it may be enforced by private action, Courts normally start by examining the 4 factors set forth in Court versus Ash. Applying those factors, it is simply clear that Congress intended to grant public access producers, such as Glendora, a private right of action to secure their freedom from cable operator editorial control. I'll do that again. Glendora is clearly Congress intended to grant public access producers, such as Glendora, a private right of action to secure their freedom from cable operator editorial control. First, Glendora is among the class for whose special benefit Section 611E is enacted. Second, although there is no explicit indication of legislative intent to create a private right of action, there is an implicit indication of such intent. Absent a private right of action, there is only one express remedy available to Glendora under the 1984 Cable Act: enforcement of any franchise requirements relating to public access channels. That was Nella Alpucci, who just broke the law. And she thinks it's very funny, and that's her level of maturity, and she's also stealing somebody else's parking place. And she still thinks it's funny. You hear her laughing? Now, this express remedy is not spoken of in terms of exclusivity and is permissive in nature. Moreover, it is highly unlikely that any town within Nassau County would choose to enforce the free speech rights of a single public access producer, especially one who has criticized local public officials. Third, an implied right of action is fully consistent with the underlying purposes of the legislative scheme. Let me make the note of what time she did that, 2:31 p.m. One of the central purposes of the 1984 Cable Act was to ensure that cable communications provide and are encouraged to provide the widest possible diversity of information sources and services to the public. That purpose is clearly served by creation of an implied right of action to enforce the ban on cable operators' editorial control of public access channels. Finally, the cause of action created here is not one, quote, traditionally relegated to state law in an area basically the concern of the states. Very good, unquote. Indeed, the 1984 Cable Act not only evinces Congress's concern with diversity of information services and sources over the cable medium, but also evinces its desire to, quote, establish a national policy concerning cable communications, unquote. Now, for all of these reasons, Section 611E is enforceable by public access producers such as Glendora through an implied right of action. Conceitedly, Glendora did not assert a claim under Section 611E in her pro se complaint. The allegations of her pro se complaint are, however, held to less stringent standards from formal pleadings drafted by attorneys, and as already noted, should be, quote, liberally construed, unquote, in the pro se plaintiff's favor. Moreover, Glendora did belatedly attempt to assert a claim under Section 611E in the court below, and has asserted such a claim in her subsequent lawsuit against Cablevision, which is also on appeal in this court. Now we're up to 3, and this is the relief requested. I just hold it up to the screen and you can read it. It's a good camera, Canon. You make a good lens. Woo. The principal facts set forth herein are largely uncontested. Glendora was denied a series on the public access channels carried by Cablevision in Nassau County, and the denial was based upon content. Because these material facts are not in dispute, this court can direct a result based upon the legal issues presented. Isn't that nice? There's no dispute of facts, and Kalaji said so. He said so orally, and he said so in writing. As such, the dismissal of the complaint was clearly improper. Under any view of the facts, Glendora sets forth a claim under Title 42 United States Code, Section 1983, for violations of her free speech rights and of Section 611E of the Cable Act, and a direct claim under Section 611E by an implied right of action. Alternatively, she plainly avers, at the very least, facts which, if true, would constitute state encouragement. Taken as true for purposes of a motion to dismiss, they certainly set forth, quote, state action, unquote, sufficient to constitute a claim under Section 1983. That's the Civil Rights Act. Moreover, because the complaint was verified, the facts stated which are uncontested support Glendora's motion for preliminary injunction. The standards for issuance of a preliminary injunction in this circuit are well established. Plaintiff must show that she is likely to suffer irreparable harm if equitable relief is denied. Plaintiff must also demonstrate either A, a likelihood of success on the merits, or B, sufficiently serious questions going to the merits of her claims to make them fair grounds for litigation, plus a balance of the hardships tipping decidedly in her favor. There's Nella Alpucci again. There is her horn again. The time is 2:35 p.m. That is so stupid. There's a lawsuit against her, and there's an right this day before the court. Well, yesterday was the return date for a order to show cause. We are up to the conclusion. For the foregoing reasons, Manny, which is Media Access New York, respectfully requests that the court, 1, reverse the district court's grant of Cablevision's motion to dismiss. 2, remand and direct that the district court, A, grant Glendora's motion for an injunction ordering Cablevision to restore her series to the same or comparable time slot with all due speed, or alternatively 2, consider in conformance with this court's decision the factual issues raised by Glendora in her complaint, and B, grant such or other and further relief as the district court deems proper, and 3, direct that the mandate of the court shall issue forthwith. New York, New York, September the 2nd, 1994, respectfully submitted, Robert T. Perry and Brian D. Grafman. Attorneys for Amicus Curiae, Media Access New York. You notice it's green. It has to be green because that's the color for the brief for an amicus curiae. What's my color? Bright blue. And what's the appellee's color? Red. What? Don't they know a lot? I think it's wonderful. I think it's terrific what they did. So, did you hear about the cable operator who sent the subscriber a bill? And he says, we appreciate your business, but your account has been overdue for 10 months. We've already carried you longer than your mother did. And the salesmen have great imaginations. The trouble is, folks, they use it all on their expense accounts. And here's a sure way, if you're a door-to-door salesman, here's a sure way to sell an article. You walk into the housewife and you say, here's a product that your neighbor said you couldn't afford. It'd be brilliant to put something together like that, and they put it together so fast. They served it on the other side and on the United States Court of Appeals at 11:59 p.m. 30 seconds to go on September the 2nd, 1994. But they really deserve a lot of credit, Perry and Grafman. Now, what else is going on with Cablevision? Of course, the big thing is that the program is on TV tonight in Long Island as a result of the lawsuits. That's the big thing. And then we have the article. Well, so what's going on with Cablevision? Are they got the bad press. The New York Times, the New York Law Journal, Connie Chung, and Broadcast New York they got that. And maybe, and I keep sending them the TV logs, the Glendora TV logs. Here's a great big one that went out Sunday. And it goes to James Dolan, and I guess to Lemley, and I guess to Lusgarten, and I know Randolph maybe. There were 5 of them that went to Tata, certainly Tata. And it talks about another cause of action against them being the New York State Business Corporation Law, and listing, many laws that they possibly break. Because that notice of motion to get a stay from the appellate division hasn't shown up yet, and may never. So maybe they're ready to call it quits. This execution from the Westchester County Clerk, in the hands now of the Nassau County Clerk, Sheriff Carano out there, is going to Cablevision today or tomorrow for collection of how much money? $779, which was my cost in the lawsuit 2 case that went before Judge Silverman. There's been 2 articles in the Gannett newspapers about the air in the county courthouse. Judge Barone and Judge LaCava claiming injury to their health. And then 2 other judges joined them. One is my judge, Colabella, that I'm waiting for a decision on from modern courts. Maybe that's why it's taken him so long to make the decision, because the air is bad. And then another judge, Judge Lange. Lange is the same name as the clerk of the United States Court of Appeals. So there's that's going on. Maybe you can blame some of those bad decisions on the bad air, right? Some of those bad decisions that come out of the Westchester County Courthouse. And they wanted a copy of a videotape of the program before Cablevision took it off the cable in Long Island. But that would be 2 hours work going into the archives. And then you'd have to pull out an archive copy, and there'd have to be a copy made of it, and that adds up to travel time and dubbing time and editing time, which I have none to spare. And so I said no. And anyway, this isn't that much different than the programs that are currently on now, that are currently on. Tautology. Redundant. Onion, and here it was sprouting. And I didn't have the heart. It wants to grow. So I gave it a nice plant pot full of dirt. And it's very, very happy now. It's about this big. Box plants of the youngs, in addition to that poor tree that they threw out and pulled out of the pot. I put it back into the pot. Gee, the tree is so thrifty now. So happy. It's growing. New leaves sprouting. Mary says, just think of all the food bills you're going to save if you'll buy this freezer. And Mary says, well, we're buying a car on the bus fare we save, and we're paying for a washer on the laundry bills we save, and we're paying for a house on the rent we save. We just can't afford to save anything more. This is a business corporation law, and I'm sending to Cablevision some notices of it. Oh, you think that's interesting, Ginny, huh? You want to approve of that before I send it? Huh? You sure you approve of it, Ginny? Of September the 9th, 1994. Here's a violation of the release, and and also a violation, I think, of the real property law. This is a common area. This is a abandoned bicycle. Has asked 4 or 5 times for this to be taken out of the common area, and the landlord has not done so. The storage bins are very nice, and it's a lovely cellar. The cellar floor was painted. On September 9th, we'd worked about 7 hours on it. Times, let's see, yeah, it'd be about 8 hours. 4 hours each person. It was hard work, but it was a great source of joy. And then Roberta's insults and abusive language. Saturday, as you can see, 2 vehicles are in one parking space. That's the vehicle Daniel Walsh drives. This is the vehicle that Roberta Walsh drives. And as you can see, this vehicle